Without further ado, I'm going to continue my talk here today, and I'm talking a little bit about a few topics. This is coming from the potpourri of questions that I've been receiving. You know, there's a little bits of issues here and there that people are interested in learning more about. So today I'm going to talk a little bit about your spouse or your children or your ex-spouse, children from a prior marriage, and what happens to these family members once you're gone, when you die. Now, these talks that I'm giving here are for educational, informational purposes. I like to be able to provide a little bit of education, a little bit of information, and I usually like to do that in person. But that's not something that we're doing these days. So I do appreciate the opportunity to live in an age where we're able to Zoom and YouTube and those kinds of things. But again, these platforms should not be substituted for specific legal advice. You should always obtain legal advice on your specific circumstances before you act. That's just prudent. Now, talking on estate planning, dealing with second marriages, and accounting for children from prior marriages, or protecting your children from themselves. I'll get into a little bit about what that means. First, I'd like to start the talk about spousal rights. What happens with your spouse, family members, once you're gone? And like my last couple of talks, I have prepared a little slide presentation here to save you, the viewer, from staring at a lawyer. So let me take you to my slide here now. And there we are. All right, we'll start here with a discussion about Homestead. Homestead in Florida. Homestead is your home, where you live. Now, in Florida, if you have a spouse or a minor child, you can't leave your home to just anybody when you die. Under Florida law, when you die, your homestead can't be devised if you leave behind a spouse or a minor child. Now, you can devise the homestead to your spouse if there is no minor child. A little exception there. If you are survived by a spouse and lineal descendants, like children, then your spouse takes a life estate in the homestead, with the remainder going to your children, your descendants. So after the spouse passes away, after their life, then the home will pass to your descendants equally. Your spouse has the ability to substitute that life estate in the home and take a 1/2 interest in the home instead, sharing the other half with your descendants equally. That 50% election must be made within 6 months of your death. Your spouse must make that election within 6 months of your death, and the election must be filed in the county where the home is located. The intestate share. Now, intestate is the word, I spoke about this a couple of webinars ago. Intestate is the word we use when somebody dies without having a will. If you don't have a will when you die, you are subject to Florida's intestacy laws. Intestate, again, you didn't have a will. So the intestacy laws are Florida's default plan, the plan that Florida puts in place for you when you pass if you don't have a plan that you created for yourself. Again, no will. Now, if you die without a valid will, intestate, in Florida, then your spouse, your surviving spouse, they're entitled to receive your entire estate if you have no descendants, or if your descendants are also the descendants of your spouse. So what that means, your spouse can take your entire estate if you have no descendants, or if you and your spouse share descendants. So if you and your spouse have 3 kids, and those 3 kids are the same 3 kids from you and your spouse, it's not a prior marriage, anything like that, your spouse is entitled to receive the entire estate. Now, if you have descendants that are not also descendants of your spouse, say you have children from a prior marriage, then the intestate share for your spouse would be 1/2 of your estate. They're entitled to 1/2 of your estate, with the other half being shared by those descendants. Or your spouse is entitled to 1/2 of the estate if you and your spouse have descendants, say you have kids together, but your spouse also has descendants that are not yours. So say your spouse has children from a prior marriage. Those are two examples where your spouse would be entitled to receive 1/2 of the estate. And again, the spouse is entitled to receive the entire estate if there are no descendants, if you have no descendants, or if you and your spouse share descendants. An elective share. What is an elective share? Well, in Florida, you're not able to just unilaterally disinherit your spouse. You can't sit down by a candlelight and clandestinely write your spouse out of your estate with a pen and a will. It doesn't work that way. Under Florida law, your spouse has the right to elect to receive a 30% share of the elective estate. So keep that in mind for any of those who are trying to write their spouse out of their estate plan. Now, issues here with subsequent marriages. With what we've talked about here, about what your spouse is entitled to, there are some issues that come up when you're remarried. Now, whether that be a second marriage, a third marriage, or fourth marriage, and so on. Imagine Jack and Diane. Jack and Diane, newlyweds, who both have children from prior marriages. Jack has 2 sons and Diane has a son and a daughter. Now, they're married after their former marriages, and they go and move to Florida and buy their dream home in Florida together. And they want that house to pass to their children, Jack's 2 children, Diane's 2 children. They want that house to pass equally between those 4 kids when they're gone, when they die. Now, Jack and Diane, like a lot of people, unfortunately, did not have a plan in place. They didn't even so much as have a will, neither of them. So we're looking at Florida's default plan, as we discussed here just a minute ago. And in that scenario, if Jack passes away under Florida law, the dream home is going to go to Jack's children at the end of the day, and Diane's children will not have an interest in that home. Now, that's not a scenario that Jack and Diane obviously would have wanted, and nor is it something that they foresee. A lot of people just think things are going to work out when they're gone, and that is not the case. Planning is prudent. Possible solutions here. Pre or post-nuptial agreements. Now, a lot of people, when they're talking about prenuptial agreements or post-nuptial agreements, they think of gold diggers. They come with a reputation of gold diggers, somebody who's trying to get their hands on somebody else's money, and you need a pre or post-nuptial agreement to protect them. Now, that's a movie scenario that you see most common, but pre and post-nuptial agreements are good planning tools, and they can be used to plan for children from a prior marriage. They are contracts between a husband and a wife, pre or post-nuptial agreement, spousal contract. They establish rights that are being waived that are provided to you by law, or rights that are being reserved. Pre or post-nuptial agreements should always be in writing, and they should be signed by both spouses. Now, one little planning tool that I have to dovetail off of this that I didn't include in my slides here is life insurance. You know, folks who want to make sure that they're accounting for children from a prior marriage, or somebody who's a non-family member, somebody who you've thought of as a family member your entire life, and you want to make sure that they're accounted for. You want to be able to provide them with something when you're gone. A good tool for this that I see a lot of clients utilize is life insurance. You know, people will in order to maintain familial harmony, in order to maintain spousal harmony, you don't want to mess with your estate plan too much. Then there are those clients who will decide to take out a life insurance policy and name a particular individual that they want to receive those funds. Or they could name a trust to receive those funds, which leads us into our next possible solution, using a trust. Now, if you wanted to use a trust. A trust is simply a vehicle that holds assets on behalf of somebody. So if you wanted to say, have life insurance proceeds go into a trust for the benefit of a friend or a child, you can do that. And that trust is managed by a trustee. You could be the trustee of your trust, and you can name whoever you want to be the successor trustee of that trust. The assets in that trust don't need to go directly to your beneficiary. Instead, the beneficiary receives distributions according to the terms of that trust agreement for particular purposes. This trust also works to protect financially irresponsible children from themselves. And as we said in the beginning, protecting your kids from themselves. Jack and Diane, our couple from our previous example, their son Gomer, real good kid, real nice guy. He big heart. He spends money like he prints it, giving it to his friends, giving it to his favorite charities, throwing parties. He bought his friend a car. Just isn't very good with money. Big heart, but will lose his money in no time flat if he's left to his own devices. So of course, Jack and Diane would like to be able to leave money to Gomer. They just don't want to leave a lump sum of money to Gomer in fear that he is going to squander it within a year's time. So a trust in this scenario would work where the trustee would be able to provide Gomer with funds as he needed it for particular purposes. You know, whatever those may be, whatever you decide is prudent for your particular circumstances. And that could be for payment of rent. It could be for car insurance. It could be for medical expenses, whatever the case may be. Again, it's up for you to decide. But it is a possible solution for not only for accounting for a particular person, a child or a friend or whomever it may be, but it's also a way to protect that money from the beneficiary if they are not a financially prudent individual. Now, some other considerations here when we're talking about spouses, and that is to make sure that you've updated any ex-spouse named as a beneficiary on any death benefit, life insurance policy, annuity, 401k, and any financial account that you would have a named beneficiary designated. You would want to make sure that those are updated. Florida has laws on the books that will presume your wishes in a divorce scenario. So if you divorce your spouse and you've listed them as a beneficiary on one of these payable on death accounts, then Florida can void that designation, which could leave benefits going to your estate. Now, a lot of people who put a lot of time and planning into avoiding probate would not like to have an asset fall through the cracks and end up going into probate just for that one reason. Now, an example here would be a client, a recent client, who planned against probate. They did everything that they could do to try to avoid probate. And the one problem that they had was their IRA. Their IRA was left rendered with no beneficiary. There was no beneficiary named on that IRA. And unfortunately, we needed to file a probate for that asset only, just to be able to have the proceeds from that IRA distributed to the children of the deceased. A single man who only had children. And that is not a scenario that the deceased would have wanted. There was a lot of money involved in administering that probate that would have been saved completely by the deceased, and the proceeds then gone to the beneficiaries had that beneficiary designation been updated. So that's not what we wanted to see. That client ended up, paying upwards of $10,000 in fees solely because the beneficiary wasn't named. These are things that can be avoided. Now, you may not be able to leave all or some of your assets to your children. And another example, our clients who, like Jack and Diane, they wanted to leave, well, Diane wanted to leave a house to her children. And her husband, Jack, had his own children, but Diane owned the house prior to she and Jack getting married. So she wanted to make sure that this house that she'd bought while she was a single woman went to her 2 kids. Even though she was now married to a husband and he had his own kids, she wanted to make sure that that house she purchased by herself when she was single went to her 2 kids. Now, from what we discussed previous, we know that that would not be the outcome in every played scenario here, without planning. So long as what we did for this client was we entered into a postnuptial agreement. We entered into a postnuptial agreement where her husband, Jack, waived his homestead rights. He waived his homestead rights in that postnuptial agreement, which left Diane free to devise that home as she wished, which she ended up giving Jack a life estate in the home, and then the remainder would go to her 2 children only. But it was a way for her to ensure that that plan happened. That home that she'd purchased when she was young and wanted to make sure that it stayed with her family, she was able to do that. That may not have been the case had things transpired without planning. So just another consideration there if you are trying to leave an asset like your home to your children, but they are children from a prior marriage. Communication is key when you're doing your estate planning. It's not a comfortable topic for a lot of reasons. People don't like to talk about their death or planning for it. But it is a great service that you're able to do for your family, making everybody else aware of your plans and how you would like to see things happen and how you plan to have things happen. You don't want surprises left for your family members after you're gone. And it's very upsetting to see the destruction of family relationships over seemingly minor issues. And the deceased usually would not want to find out that their family was pulled apart in any way, shape, or form based on their lack of planning before they left the earth. So again, communication is just something that I always recommend between family members. Don't hide these things. Don't keep them under lock and key because they're just too depressing to talk about with your kids or your other family members. Put it out there, talk about it, make everybody aware, and if it's uncomfortable, make it uncomfortable just for a little bit so everybody's in the know. And that way they're better prepared when the time comes. That's one of the greatest gifts that you can give to your children, in my opinion, of course. Now, we're at the end of my slide presentation here, and I hope this provides just a brief overview of spousal rights, planning for children of a prior marriage, or planning for children that are not as financially responsible as you would like them to be. I do have some questions that I've had sent to me that I will ask here and answer now. Go ahead and get rid of my screen here. Okay, and there we're back. Now, let's see. I've got a few questions here. Okay. What is a family allowance in a probate? Family allowance. Not a very common topic, not a question that I've been asked very often, but a family allowance under Florida law in a probate action, when you die, your surviving spouse, they're entitled to an allowance, a reasonable allowance. And that would be from the probate assets, and they would be payable to your spouse for a maintenance sort of payment. The maximum amount that they could be paid for family allowance is $18,000 under Florida's law. And it can be paid in a lump sum, or it can be paid in installments. Now, it's not automatic. It's only awarded after you petition and you ask the court. And you don't need to prove that you need the allowance, but the amount must be established. The reasonableness of the amount that you're asking for, that needs to be established. Okay, so a family allowance is just a way to assist the surviving spouse with finances when going through the probate process if needed. I hope that answers your question. Now let's see. The next question I have, this was a question that I got last week and I didn't have time to cover it, so I wanted to make sure that I loop back around. And Kay asks, will I need a probate for my husband who owns commercial farmland in Ocala? Ocala, more rural area, city out here in Florida. And well, without having more information on that question, without having more facts, if Kay, if you're not a title owner on that property in Ocala with your husband, if it's, you say it's commercial farmland, if you're not also a titled owner of that property, then you'll likely need a probate. You'll likely need a probate for your husband, which is unfortunate, I know. It's not a unique circumstance. There's actually another client that I had who had a similar circumstance, she'd come to see me for another reason. It wasn't to do with her estate plan. And she had told me about her husband had passed and he owned some land, same kind of situation that you're asking here, this commercial farmland in Ocala. Her husband owned some land, and she found out she needed to get a probate to have that title taken out of her husband's name, put it into her name. She can sell it, take the money, do what she needed to do with that money from her husband's land. She ended up going to a probate attorney that went to her church. She told me that she and her husband went to this church for years and years and years, sat next to this attorney for 40 years or more in church. That all sat next to down in the front right-hand side. They all sat next to each other. So after her husband passed, she approached this attorney church friend and asked if he would be able to help with the probate. Hey, look, I found out I needed a probate for my husband's land. I don't know what that is. I don't know what's entailed. Can you help me? And she said, of course. He said that he would help her. Yeah, no problem at all. We'll get the process started. We'll get the ball rolling. She was very friendly, very helpful, did everything just as he should. But it was a process. You know, she had to complete some paperwork, and they had to file some things with the court, and had to get some paperwork back from the court. Judge had to sign some things, and you know, a matter of months, I suppose 6-8 months, they were all done. Everything was wrapped up, and she was able to have that land in her name and go sell it and get the proceeds from it. And she then found out that that attorney friend who sat next to her in church, and she never thought about the cost before. That's where she was so surprised. She'd said that she'd sat next to this attorney so long in church together with her husband while they were alive that she kind of thought he'd just do it for free. But when she found out what the cost was, she ended up paying that attorney $30,000. That attorney's fee, which was completely allowed under Florida's law to receive that fee. So the attorney ended up having a $30,000 fee for the completion of this probate just for this piece of land. Now, obviously, the client felt like she was taken advantage of. And again, this is just one of the traps and pitfalls of a probate. She said that her husband would have planned differently had he known what she now knows. So I hope that answers your question. I have a tendency to answer questions in stories a lot of the time. So I hope that story, you have very similar circumstances there. I hope that helps to answer your question. Let's see here. Our next question I have is, what happens if I get married? I don't know. Yeah, okay. What happens if I get married after I've already made my will? Okay, well, in Florida, we call that a pretermitted spouse. If you were married after you've already done your planning documents, then under Florida law, your spouse would receive an intestate share. If you remember intestate, you'd die without a will, as we talked about previously. Under Florida law, your spouse would receive an intestate share under Florida's intestacy laws. Now, this is the case so long as, one, there isn't a pre or post-nuptial agreement in place. Two, the will provides for the spouse. Or three, the will discloses an intention to not provide for the spouse. And Florida law under section 732 allows you to do that. Okay, so if you were a pretermitted spouse, a spouse who became a spouse after planning documents were already in place, so you would then be accounted for, your spouse would be accounted for under Florida's intestacy laws, unless you had those three circumstances present that I just spoke about. All right. I think I'm at the end of my questions here, and it looks like I am at the end of my time. I hope that you have all found this beneficial. I hope it provides just a little bit of information for you, even if it's enough for you to go out and learn more about your particular scenarios. What I really want to have people avoid are the probate consultations that I get. The people that come into my office after something has happened, after somebody has died, or after somebody has been injured and is disabled or is incapacitated. I really enjoy seeing clients before these things happen so that we can put the picture together how it will look when something like that happens. You know, everybody's going to experience death. We can't escape that. You may not experience disability or incapacity, but everybody will experience death. And if we're able to sit down and we're able to put a plan together to make it easier, not for you, obviously you'll be gone, but for your family, so that we don't see what us estate planning practitioners see a lot of the time, and that's acrimony between family, fighting. You know, there's nothing worse than watching families fall apart because of what dad is wearing in his coffin, or because of, I want the lamp and I'm sure he would have wanted me to have that lamp. You know, these kinds of little seemingly nonsense issues can really do a number on families when they're experiencing a time of grief. So again, communication, like I talked about before, that is key. Communicate not just with your attorney or your estate planning professionals, but also with your family members, the people that will be dealing with all this grief and emotion and stress and business once you're gone. There are ways to put things in place to make that more palatable for all those involved at the end. All right, please keep your questions coming to me. I had my email displayed there. I like the questions. Make a phone call if you'd like. I have no problem talking on the phone, or make an appointment, and we can either talk in a video format, or as things start to loosen in terms of restrictions going out and about, then hopefully soon we'll be able to meet face to face and talk about your particular problems, issues, and solutions. All right. Thank you, everybody. Have a good rest of the week, and we'll see you next time.